Good morning. Welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal from the Court of Appeal of the Turks and Caicos Islands in the matter of Scilly Creek Estate and Marina Co. Limited and the Attorney General of the Turks and Caicos Islands. The case concerns a dispute over planning permission. I'm Lord Lloyd Jones. I'm sitting today with Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Stevens.
Good morning.
And Sir Keith Lindblom.
Good morning.
The appellant, the Attorney General of the Turks and Caicos Islands, is represented by Helen Mountfield, Queen's Counsel, and Rowan Pennington Fenton.
Morning.
Respondent, Scilly Creek Estate and Marina Company Limited, is represented by Ariel Missick, Queen's Counsel, Deborah John Woodruff, and Shante Francis. Miss Mountfield, before you begin your submissions, I think my Lord Sir Keith Lindblom has a question for you.
This follows from what my Lord Lloyd Jones has said about the planning history. We are very keen to get a clear picture, complete picture. We have, of course, the grant of development permission to subdivide land of December 1994. We now have the application, which, as we understand it, was the basis for that approval. We do not have any other development permission for us originating from that time. We are very keen to understand whether there were any others. That would be my first question. It may be helpful if I just add the second for you address that. If we come forward in time to the entering into of the settlement agreement and the Scilly Quay lease in 2006, the question the board has, Miss Mountfield, is whether at that point there were any outstanding, that is to say undetermined, applications for development permission. We need to have a clear picture of that. For the moment, those two questions, I think, would be the ones I would ask you please to help us with straight away.
Yes. My Lord, my understanding of the matter is that the 1994 subdivision application was made and determined. And it appears, although we do not have it in the bundle, that there was a 1995 application to build a road, and I haven't seen that. But apart from that, my understanding is that there are no formal planning applications in respect of Scilly Quay. There were some in relation to Scilly Creek, but not Scilly Quay. And I understand it, Mr. Missick's case is that the 2006 settlement agreement and lease in some way turned a conditional outline consent of some kind arising from the 1994 subdivision application into some more certain kind of consent. And my submission is it doesn't, but that's my understanding of the position in relation to applications. And it will be part of my case that there weren't any.
I think it's going to help the board to see the full picture, including development permissions relating to Scilly Creek. We do have the complete picture.
Yes.
Are you now going to turn to the second question?
Well, before Ms. Mountfield does that, I should just say that we are therefore going to ask the parties to produce an agreed document, which will be a complete account of the planning history with cross-references to documents, including exhibiting those documents which we don't already have in the bundle. It's important that we have in a single document a complete picture of how this has developed. I'm minded to say we should have that within 7 days. Ms. Mountfield?
Yes, no problem.
Mr. Missick? Sorry, you're muted, Mr. Missy.
Yes, my lord.
Yes, thank you very much. Good. Ms. Manfield.
Yes. Well, my lords, good morning. We've had the introductions, but as you've seen, the appellant is the chief law officer of the Turks and Caicos Islands and represents the Crown. And the respondent company was created in 1994 with a view to developing both Scilly Creek, which is outside the national park, although it is Crown land, and Scilly Quay. And Scilly Quay, as you've seen, is within the Chalk Sound National Park, as designated by Section 3 of the National Parks Order. You can see that parcel of land clearly at page 235, but perhaps if I took you to the supplementary bundle at tab 2, page 10, the lines aren't very clear, but the Chalk Sound is the enclosed area of water, and you can just about see a white, on my copy, a white line that goes round Chalk Sound and a very little bit of land around it. It then comes in on the inside of Scilly Creek, and the sort of the little finger of land through the middle is outside the national park. The national park boundary then comes round, and you can just see a little island just above the PPL of supplemental bundle, and that is Scilly Quay. And in 1995, the respondent, as you've heard, leased various parcels of land in Scilly Creek from the Crown with agreed permitted user for residential and commercial development. And I won't ask you to turn it up, but the reference for that is in the record at page 311 of the electronic bundle. All my references are to the electronic bundle. And the then intended uses of that land are in an equality impact assessment that you see at page 262. It's important to appreciate that the land that was demised under the 1995 Scilly Creek lease didn't include Scilly Quay. But the 1995 lease did include provisions as to the circumstances in which it might be extended to include Scilly Quay, which related to the amount of development that had been undertaken on Scilly Creek. Now, there was litigation as to whether or not those conditions had been met, and following that litigation, the settlement agreement, which you've seen, was entered into on the 10th of October 2006, and that's in the record at pages 341 to 343. Again, I don't think I need to ask you to turn it up in view of the tight time slot, but that settlement agreement said that the Crown acknowledged that Scilly Creek had met all the requirements in the 1995 lease for inclusion of Scilly Quay in the lease, and approves the land use plan as it relates to the property. Now, the land use plan is at page 345 of the bundle, and it's quite hard to see. R stands for residences, but it's common ground, I think, that there were 8 lots on that land use plan for the tip of Scilly Quay, and 5 residence and guest house plots, 1 plot for a residential club and a restaurant, and 2 parks. And it may be material just to note at this point that that land use plan in the 2006 lease is not entirely identical to the master plan, which was submitted with the 1994 application to subdivide parcels of land, which is at 262. That has 1 lot down as a private beach club and pool house. So they are slightly different, and that may be material in looking at whether the settlement agreement in some way revived or made unconditional some sort of conditional permission granted in 1994. The settlement agreement did not, in fact, as had been envisaged in the 1995 lease, extend the demised premises under that lease to include Scilly Quay. Instead, a new lease was entered into, and that's at Schedule 2 to the agreement, page 346, and I'll describe that as the 2006 lease. And the appeal arises from a statutory application which the respondent made under the terms of the Physical Planning Ordinance on the 22nd of September 2009 for planning permission to build a valuable private house on Scilly Quay in the plot labelled R1. Now, the application is in the record at pages 372 to 377. If you look at I think I've shown you where it is. I think the most important document is that the application then, having been made, accompanied by the EIA that had accompanied the 1994 application for subdivision of land. The application for planning permission, development permission for the house was refused on the 27th of November 2009. And it is important to turn that up. It's at page 386 of the bundle. You'll see at the top right-hand corner of that page, form DOP 14, which in due course I'll show you is a statutory form specified in regulations made under the Physical Planning Ordinance for refusal of permission to develop. It says the board hereby refuses to grant permission to carry out the following development: main dwelling and ancillary facilities. And then it says this: the reasons for the board's refusal are as follows. The principal development is located within the Chalk Sound National Park. In accordance with section 4.1a of the National Parks Ordinance 1998, the proposed development is of a type which cannot be allowed in a national park and shall be deemed refused. The date of that explanation is important in view of some submissions that Mr. Missick will make in due course. That refusal was upheld on appeal. You see the record of that refusal, and it's a bare record. I don't think we need to turn it up at pages 396 to 397 of the bundle. But the respondent took the view that the settlement agreement and lease had given it, against the background of the 1994 Subdivision Commission, had given it either a statutory right or a legitimate expectation of residential development at Scilly Quay, and issued a writ in the Supreme Court to challenge the legality of the refusal and to seek damages or a restitutionary remedy. The re-amended statement of claim, re-amended on the 22nd of March 2016, is in the bundle between pages 11 and 30. As you'll have seen, the Chief Justice of the Supreme Court, Ms. Ramsey Hale, heard the claim over 3 days in March 2017, and in her judgment on the 18th of October 2017, which is in the bundle at pages 65 to 69, she held that the decision in 2009 to refuse planning permission was not only a lawful one, but the only lawful decision which could have been made, having regard to the terms of Section 4 of the National Parks Ordinance, which would have made the grant of development permission for development of that kind in the national park unlawful. And she also held that the settlement agreement could not have bound the Crown to grant planning permission for the development in the national park, because the Crown could not lawfully bind itself as to future exercise of administrative discretion. She cited the Amphriti case. Of course, there are many authorities for that proposition. She also held that the respondent's remedy, if any, for the breach of lease lay in damages, but because she held this had not been properly pleaded, she dismissed the claim, and that's at paragraphs 19 to 21 of her judgment at page 69. But the Court of Appeal, in a slightly more lengthy judgment in the bundle between pages 77 and 107, took a different view. The Court of Appeal held that by the terms of the settlement agreement, the Governor had already exercised his discretion to approve housing development. You see that in paragraph 72 of the Court of Appeal's judgment on page 103. So the Court of Appeal held that there had been a breach of the respondent's legitimate expectation that it would be permitted to proceed with housing development on that site. That's in paragraph 76 at page 105. And it also held there was a breach of the constitutional right to property at paragraph 77 on page 106. And the Court of Appeal said that the respondent should have had an opportunity to particularise its claim for damages before having it determined, because the court at first instance had ordered a split trial on liability, as a result of a consent order to that effect. And that's on page 62 of the bundle. Now, it's right to point out that any claim for damages or other form of compensation currently rests remitted to the Supreme Court. That's what the Court of Appeal said in paragraphs 78 and 79, and there is no appeal against that finding. So the first instance proceedings are not complete because that hearing remains to be determined. But on this appeal, which is brought by permission granted by the board on the 10th of July 2019, the Crown does challenge 4 of the Court of Appeal's findings on liability. The first is that from the date of the settlement agreement in 2006 or earlier, the respondent already had some extant form of outline development permission to build a house or houses at Scilly Quay. The second is that the respondent had some form of substantive, or it would appear it is submitted or argued substantive legitimate expectation that the governor would act so as to permit it to build a house on Scilly Quay, whether by grant of detailed development consent or by taking Scilly Quay out of the national park. The third is that it was the third challenge is to the Court of Appeal's decision that it was appropriate for it to consider a new constitutional law argument not developed in the Supreme Court at first instance and not developed in pleadings. And fourthly, we challenge the finding that by declining to grant development permission as sought in 2009, the Crown was in breach of a constitutional right to property. So with that brief summary of the background, I turn to the issues of law before the board. The first issue of law is whether the appellant was precluded from refusing to grant development permission for the respondent to build a house in a national park on the basis that it was not a suitable form of development in the national park, either because a past exercise of statutory discretion meant that that decision had already been taken and it couldn't retake it, or because it had engendered a substantive legitimate expectation that development permission of that type would be granted. The second issue of law is whether the board, if that were right, if there were if the appellant were precluded from refusing to grant development permission, whether the board ought to consider the issue raised in the Court of Appeal as to whether this amounted to a breach of the constitutional right to property, and the fourth is whether, if so, there was any such breach. And the respondent's principal submission in this case, which was accepted by the Court of Appeal, is that the appellant already had some kind of statutory development consent when in 2009 it applied for detailed planning permission for a house. That's the core of the respondent's case. And so it says the governor had in fact already exercised his discretion to grant, it seems, outline development permission for residential development by entering the settlement agreement in 2006, which meant, says the respondent, that permission already existed and it couldn't be resolved from. And it appears to say that the governor exercised his Section 4 discretion, as I've said, on the 17th of October 2006 by entering a settlement agreement which bound him to give favourable consideration to a future application for development permission of a particular type, which was described as residential development on the land use plan on 345 and in the 2006 lease as a permitted user. But we submit that whatever the contractual or equitable consequences of the settlement agreement and the 2006 lease may have been, this is simply a misreading of the statutory scheme. The Physical Planning Ordinance and the National Parks Ordinance themselves set out the exclusive and mandatory processes through which development permission may be sought and granted, or, as in this case, refused. And once those schemes are properly analysed, we submit that there is simply no conceivable basis for saying that any form of extant development permission had been granted at Scilly Quay before the 2009 application for permission was refused, as it was on the 27th of November 2009. We also submit that neither the settlement agreement nor the 2006 lease could have engendered any legitimate expectation that private residential development would be permitted to proceed at Scilly Quay. And we say that for 4 reasons. Firstly, because the terms of the lease and the settlement agreement could not, on true construction, have been read as containing any clear promise to the respondent devoid of any relevant qualification, having regard to the complete terms of the lease, and particularly clause 6.5, which is at page 355. So no promise devoid of relevant qualification. Secondly, because in any event, any such private promise would clearly have been ultra vires section 4 of the National Parks Ordinance, and the governor couldn't have bound himself to act in a way which was unlawful. So to the extent that he promised to do so, any promise was void and of no effect, including as the basis of a legitimate expectation, and that's very clearly the law from the speech of Lord Neuberger in the United Policy Holders case. The third reason, and that there couldn't have been a legitimate expectation, is because, as the learned Chief Justice pointed out at first instance, there is a very long-standing authority that the Crown cannot bind itself as to the future exercise of discretion, because public discretions must be exercised at the time that they come to be considered in the public interest. So the governor simply couldn't have said what would happen on an application for development permission in 2009 when he entered a contract in 2006. And fourthly, and in any event, the national interest in preserving the national park was a proportionate reason to depart from any such expectation. And finally, we say that the Chief Justice was correct in her first instance decision to hold that the remedy, if any, for disappointment in relation to promises in the lease or settlement agreement was in damages. And I note here that the respondent pleaded at paragraph 112C of the amended particulars of claim, that's at page 28 of the bundle, for a restitutionary remedy, an equitable remedy. I don't believe, but I wasn't, of course, present in the Supreme Court or the Court of Appeal, but I haven't seen anything that suggests that that argument was developed. And I note that the way it was particularised relates to its alleged loss rather than the appellant's alleged unjust enrichment. But that aspect of the claim doesn't appear to have been pursued, and it may be that that's a matter that's live in the remedies hearing in the Supreme Court. But in those circumstances, we submit that to the extent that the respondent has any private law rights, they arise from the settlement agreement and the lease, properly construed with the void covenants removed. So its private law rights are protected. There are still proceedings outstanding in relation to what that means in monetary terms, but there is no breach of any constitutional law right to property which falls to be considered at this stage, even if, which we don't accept, any properly pleaded constitutional law breach was before the Court of Appeal. So those are my 4 topics: extant permission or not, legitimate expectation or not, constitutional arguments arising for consideration or not, and finally why there wasn't a breach of the constitutional right to property in any event. So turning then to the first issue, whether or not there was an extant permission to develop, my submission is that a great deal of this case, in fact, arguably all of this case, turns on the correct treatment of the respondent's assertion that he'd already had some form of extant permission to develop houses from October 2006, with only questions of detailing and building regulations consent to be agreed. And we say that that is a completely untenable argument once you look at the relevant workings of the interlocking applicable statutory schemes contained in the National Parks Ordinance, the Physical Planning Ordinance, and the regulations under them. And just so you know where I'm going with this, I do need to spend a little time taking you through the provisions of the relevant ordinances and regulations, and then the means by which, as we understand it, the respondent says it acquired some form of development consent for residential development at Scilly Quay. And as I do that, I hope the following three propositions will become clear. This is the way I put my case on this aspect of the claim. Firstly, there is a clear statutory procedure, and it is a mandatory statutory procedure, which is the only way that development consent in the Turks and Caicos Islands may be sought or may be granted. There is a clear set of statutory forms which are prescribed by regulations, by which various different types of development consent can be granted or refused. And there is a planning register which shows whether and when any such consent has been granted. And if a planning consent is not on the register, we submit it doesn't exist. Secondly, there is no extant form of development consent for Scilly Quay. I bear in mind the questions we've been asked to provide in a schedule as soon as possible. But our submission is that although the respondent made an application through the procedures set out in the physical planning ordinance in 1994 for subdivision of parcels of land at Scilly Quay, and indeed elsewhere, applications for outline and detailed consent for houses elsewhere in Scilly Creek, there was no other application for development consent on Scilly Quay before the September 2009 application. We submit that the 1994 application for subdivision didn't and could not have amounted to any form of consent for residential development, and that the only such application for development consent for the building of a house was that which was lodged in September 2009. Before that, there was no valid statutory application and no grant of any form of planning permission, development permission for a house or indeed any building at Scilly Quay. There's no evidence of any such application or consent on the statutory planning register. And indeed, it's a point that emerges from looking properly at the statutory scheme. Even if the 2006 settlement agreement and lease had in some way been capable of being construed as conferring some form of outline development permission for a house or houses, such outline permission would have lapsed a year after the settlement agreement was reached in the absence of any application for detailed consent. And you can see that from section 37.1 of the physical planning ordinance, which is on page 641 of the electronic bundle, and I'll come to it when I go through the legislation. My third submission on this aspect of the case is that if, and to the extent that the governor had purported to grant planning permission for a house in 2006, the Chief Justice was correct to hold that any such grant would have been contrary to the clear terms of section 4 of the National Parks Ordinance. And that's because section 4 provided at all material times that the governor could grant development permission only as may be considered to be desirable to facilitate enjoyment by the public of the natural setting of the area. And even then, the paramount consideration, definite article, the paramount consideration had to be to limit such development to the minimum consistent with the reasonable access to and enjoyment of the area by members of the public. So any undertaking in 2006 to grant full development permission to build a house in the national park on some future application for consent would, if it had been made, been an ultra vires promise of no effect. Now, it may be a slightly laconic understatement to say that there is some lack of clarity about what happened concerning attempts to develop Scilly Quay from the early 1990s. And so that's why I will now, if I may, undertake you through a slight trudge through the various statutory procedures by which development permission of various types is sought and obtained in the Turks and Caicos Islands. Questions of land registration and development permission are statutorily defined and procedurally tightly controlled in a land registration ordinance, the physical planning ordinance, and the National Parks Ordinance and the subsidiary legislation made under them. I should say at this stage there is now an amended version of the Physical Planning Ordinance which has some quite substantially changed section numbering, which is referred to in some of the documents in the bundle, but the references I'm going to give you by reference to the electronic bundle are to the Physical Planning Ordinance as it stood at Material Times. Land registration doesn't really play a part in this appeal, except to note that there is a system of registration of parcels of land at the registered land under the Registered Land Ordinance, and that Section 21 of the Registered Land Ordinance, as it stood at the relevant time, permitted combination and some division of parcels of land, and that references in the supplementary bundle at page 70. We've set out a summary of the governor's powers to make property transactions, to enter leases under Section 94 of the 2006 Constitution, and his ability to register those interests in property under Section 25 of the Registered Land Ordinance in our written case, at pages 468 and 469 of the electronic bundle. Just for completeness, again, in case you see references to this in the bundle, there is a form of land ownership in the Turks and Caicos Islands, which I believe is derived from American law, called strata planning, which is about ownership of condominiums, but that doesn't play any part in this appeal. But there are sometimes references to strata land rights in some of these documents. So I'm going to start, if I may, with the National Parks Ordinance and the National Parks Order. That's in the Authorities Bundle at page 573. That's Section 3 of the National Parks Ordinance. And Section 3 of the National Parks Ordinance confers a power on the governor by orders to declare any area in the Turks and Caicos Islands to be a national park or an H reserve or a sanctuary. You don't need to turn it up, but at page 578 to 579 of the electronic bundle, you'll find the designation of the Chalk Sound National Park. Section 4.1a of the National Parks Ordinance, also on page 573, is the principal statutory provision concerning usage of the national park. I've just taken you to its provisions. I just invite you to note on page 572 that development is interpreted very broadly, including any change of use, the erection of any structure, and carrying out of any other works. So in relation to Section 4.1a of the National Parks Ordinance, it's important to note that the person who may grant development permission is the governor, which is unlike other areas in the Turks and Caicos Islands, where it's the director of the Physical Planning Board, or in some cases a minister, and that the only permissible development in a national park is limited to that which may be considered desirable to facilitate enjoyment by the public. May be considered is an objective term rather than the governor himself considers. It's may be considered, may rationally be considered desirable to facilitate enjoyment by the public. And obviously a house is a private facility. Now, if we turn to page 574, you'll see Section 4, subsection 4 of the National Parks Ordinance requires applications for development permission under Section 4.1 to be made applying Sections 63, 64 and 65 of the Physical Planning Ordinance mutatis mutandis, words I thought I might never say again, but there I've said them. I'll come to the Physical Planning Ordinance, but it is important to note that they do apply to applications for development permission in the national park. The fact that the decision maker is the governor doesn't mean that the procedures in the Physical Planning Ordinance are set aside. But in short, I'll turn to them in a moment, those provisions require, with the planning application, an environmental impact assessment and a recommendation from the director of the Physical Planning Board to the minister, who then must make the recommendation to the governor. So before I turn to those provisions, I'll just complete my survey of the National Parks Ordinance. Section 5 on page 575 states that private land can be included in a national park. And Section 7, at the bottom of that page, is a prohibition on any development in a national park except in accordance with the terms of a grant of development permission under Section 4 on pain of criminal sanction. Section 8 on page 576 grants the governor power to make regulations for carrying into effect the purposes and provisions of the ordinance. And so that I only need to take you briefly to the National Parks regulations. They start at page 590, but if I could ask you please to turn to page 592 of the electronic bundle. Regulation 3. Regulation 3 says that the following are prohibited within national parks, and Regulation 3.1n is the erecting of any structure unless authorised by the Director of Planning. And my submission is that that shows how, although the governor is the decision maker in relation to development applications in the national park, those applications are still tied into the general physical planning structure and method of recording whether or not there's been a grant of permission. With that, I then turn to the physical planning ordinance. It starts on page 610 of the electronic bundle. And I'll come to sections 63 to 65 in a moment, but first I want to just provide an overview of the physical planning ordinance and how it works. Most development decisions are taken by the Physical Planning Board, which you can see at section 2, or provision for the making of that, the creation of that board is at page 616 of the bundle. That's the definition of the board in section 2, and then the board is provided for in section 4. Could I ask you also please to note the definition of development in section 2, which again is a broad one. That's on page 617. And page 619 defines development permission. Development permission means permission for development given under the provisions of Part 5 of this ordinance. Parcel of land, page 620, means an area of land delineated and numbered on the land registry map. And subdivide, in relation to that, means to divide a parcel of land into 2 or more parcels. I note, but really only by way of passing observation, on page 621, section 3, that it is the duty of the minister to secure consistency and continuity in the framing and execution of a comprehensive development policy. And the minister may act through the director of the Physical Planning Board. Section 4, as I've said, establishes the board. If I can then go forward to page 623 to section 8, 1c, which gives the governor power to make regulations specifying the powers of the Physical Planning Board and for the purposes of carrying provisions of the ordinance into effect. Then section 11 on page 625 enables the governor to appoint a person to be the director of planning, and it is that person under section 11.3 who shall sign and issue all development permissions, refusals of development permission, enforcement of notices and other documents authorised by the board to be issued under the provisions of this ordinance. Section 14 on page 625 provides that it's the governor's duty, the minister's duty, and the board and the director and all other planning officers charged with exercise of powers under the ordinance to do so in such manner as to promote the development of land which is consistent with a coherent policy, B, promotes orderly development of the islands, and C, in such manner as is beneficial to the people of the islands, and C, takes into account environmental, social and economic considerations. But I also note on page 627, section 14, subsection 5, that is not a duty which you can inquire into. It's an unjusticiable target duty. Going ahead to section 16, page 628, the governor or a minister may give directions in writing to the board as to the general policy to be pursued in the grant of development permission, but there are no such directions in evidence in this case. And section, sorry, I just want to go backwards to section 15, which notes that the director and any planning officer authorised by him may discuss with any person interested in developing land or any proposed development of land. Nothing the director may say or any scheme or drawing or so on shall bind the governor, the minister, the board or the director as to the manner in which any power under this ordinance may be exercised, or to exercise any such power as the case may be, or require him to perform any duty which they would not otherwise be obliged to perform. And finally, by way of preamble, section 18 at the bottom of page 628 provides in section 18.1 that the Director of Planning is the principal advisor to the Governor, Minister and Board on matters relating to physical planning and development of land. Now, part 4 relates to development plans. It starts at section 19 on page 629, and it concerns the powers of the Director of Planning and his duty, if so instructed by the Governor, to prepare a development plan for the whole or part of the Turks and Caicos Islands. I don't need to take you through the rest of part 4. Just mention that to note that for the avoidance of doubt, the land use plan referred to in these proceedings wasn't a development plan and prepared in accordance with this part. It was a document that was submitted by the respondent with their 1994 with the 2006 lease. It's a schedule to the lease. Then I move forward to part 5. That part starts on page 634, headed Development Control. And section 28 is the general prohibition on development without development permission. Section 28.2 permits the Governor by order to provide that any development or class of development may be permitted without the requirement for a grant of development permission. But there is no such order in this case, so there's no reliance on section 28.2. Section 29, highly material provision for the purposes of this case, specifies 4 types of development permission which may be granted. Material to this case are the first 3. Section 29A, outline development permission, the effect of which is to give the grantee or his successor in title approvable in principle to the proposed development, which is the subject of application, but not to permit any actual development to take place until a grant of detailed development permission has been made in respect of the same development or part thereof. B, detailed development permission, the effect of which is to grant the grantee or his successor in title to carry out the development subject to the terms and conditions of the grant. And C, permission to subdivide land, the effect of which is to permit the grantee or his successor in title to subdivide or to make an agreement to subdivide land, which is the subject of the application, subject to the terms and conditions of the permission to subdivide land. And then if I could move ahead for a moment to section 37, which is on page 641, bottom of that page, you'll see that an outline development permission shall lapse and cease to have effect if no detailed development permission covering the same land has been applied for within a year of the grant of outline development permission, or such longer period as may be specified in the grant of outline development permission, or as may be authorised by the board. And section 37.2, that a development permission other than an outline permission shall lapse and cease to have effect if the development to which it relates has not been completed within 3 years of the grant of detailed development permission, or such longer period as may be authorised by the board in any particular case. So development permissions don't endure forever. Then if I can ask you to go back, please, to section 30, page 635 of the electronic bundle. Applications for the grant of development permission shall be submitted to the board through the director in accordance with the requirements of any regulations made with respect to such applications accompanied by a fee. And subsection 3, the director shall notify the applicant for development permission in writing of the decision on any application in relation to giving either conditions if there's a grant, if any, or a brief statement of reasons for refusal. Now, if I could turn, please, to page 679, section 89. You'll see that the governor may make regulations for carrying into the effect provisions of the ordinance, including at section 69(2)(b), the procedures to be followed and the forms to be used in connection with an application for the grant of planning permission. I need then to take you to the development permission regulations. They're slightly confusingly split, I'm afraid, in the authorities bundles, and all get in. But if I could ask you to turn to the supplementary bundle, tabs 5 and 6.
Ms. Mountfield, I'm sorry to interrupt. Just before we leave the PPO, can you just explain to me what is the significance of permission to subdivide?
My lord, that's a question I have asked myself. It is very unclear why this appears in the physical planning ordinance as well as the registered land ordinance, and it would appear that it enables you to apply for planning permission for a part of a parcel by having divided it. That is a question I don't have a very strong answer to, and I have wondered the same thing. I don't know why you need to ask that question.
I wasn't sure whether the scheme of the PPO is that you can only ask for planning permission for defined parcels.
I think my assumption, my lord, from the fact that there is a permission, you have to ask for permission to subdivide, is that is the scheme, that you apply for a parcel. But I don't have a very clear answer to that question, I'm afraid.
All right, let's not take up time on it.
Yeah.
But thank you.
So if I could ask you then to turn to the development permission regulations, which are tabs 5 and 6 of the bundle. Starting with tab 5, I think we have separate page numbers for this. It's page 30. Scope, regulation 3. The regulations apply to all applications for grant of development permission. So that's important. They apply to all applications, whether or not the governor or the board decides them. Equally important on page 31 is regulation 4. Schedule 1 sets out the forms to be used in respect to the various applications, decisions, requirements, and other matters to facilitate the administration of the ordinance. And regulation 5, an application to which these regulations apply shall be submitted to the director on the application form set out in schedule 1, which is appropriate to the purposes for which a grant of permission should be sought. And regulation 5.4, the director shall not accept any application which is not accompanied by the appropriate fee or which does not conform to any of the other requirements of these regulations. So these are mandatory. This is the mandatory way to apply for development permission. Turning to page 33, regulation 11, the director has a duty to notify a decision. So within 10 days of the conclusion of a meeting, that's of the board, he shall, on the form set out in Schedule 1, notify the applicant of the decision reached on his application. And Regulation 22 on page 38 provides for a register of applications to be kept by the director and which must contain the following information: particulars of every application made, directions, and 22(1)(c), any decision of the minister, the board, or the director in respect of the application and the date of notification. And it has to be indexed so you can find things. And then in tab 6, my lord, and I'm afraid this isn't a complete version of Schedule 1, but I don't think we need that particularly. It's an index, page 39, which gives you an index of the forms for applications to develop and so on. You'll see Form 1 is the application for development permission. I don't think we have that in the, at least not an incomplete one in the bundle, but we could obtain one. Form 6 is the application to subdivide land. Form 10 is the form for a grant of outline development permission. Form 11 is the grant of detailed development permission. Form 12 is the grant of development permission to subdivide land, and Form 14 is the refusal of permission to develop, which we saw in relation to this application. And I just note Form 21, which is an application for extension of time to implement the grant of development permission. So then if I could come back to the physical planning ordinance back in the main bundle, page 638. When it considers an application for planning permission, the physical planning board must take into account the various factors in section 34 of the ordinance insofar as they appear to him relevant. It's a long list, and you'll see from 34(1)(I) at the bottom, as well as all the factors which are mentioned, which you must consider insofar as you consider them relevant, such other matters as the director considers to be relevant. So it's a broad and open textured evaluative discretion. And then section 35. Section 35, the Physical Planning Board may, on the advice of the director and the governor's consent, enter into development agreement. And where such an agreement is reached and any stipulated conditions are met, then the Physical Planning Board shall grant development permission. Now, as I understand it, the respondent contends that this provision is relevant, but as I'll explain in a moment, it isn't, in short, because the Director of Planning entered no such agreement. Section 36 provides that...
I'm sorry, raising my hand. I appreciate you're taking us through the provisions at the moment. Your position is, as I understand it, that there was no development agreement.
Yes.
At any stage. At any stage.
Yes, my lord.
You also submit, as you just have, that the 2006 documents did not, either one of them altogether, constitute a development agreement. If we went back to the 1994 subdivision development commission, one of the conditions appears to relate to a development agreement in prospect. What happened to that aspiration, if that's what it was?
My lord, the honest answer is I don't know. But there is no development agreement in the evidence signed by the director in accordance with this provision.
But there never was at any stage a submitted development agreement or one that was included.
Not so far as I know, my lord. I'll be corrected on instruction and I'll come back to you if I've mistaken that. But I don't believe there to be one, unless Mr. Missick is right and the settlement agreement signed by the governor is one, and we say it isn't.
Right, thank you.
Yeah, so conditions can be imposed on the grant of planning permission, section 36, page 639, and then section 42 on page 644 is important because you'll see that in section 42(1), the governor may call in applications for development permission if he wants to. But section 42(2)(b) provides that the board shall refer to the governor for his decision any application for development permission in the National Parks Ordinance. And you'll recall that under section 4.4 of the National Parks Ordinance, which is page 574, I don't think we need to turn back to it, sections 63 to 65 of the Physical Planning Ordinance apply mutatis mutandis to applicants for development permission in a national park, provided that this is the language of section 4.4 of the NPO, provided that the Director of Planning shall make available to the Minister a copy of environmental impact assessment referred to in those sections before any application for development permission is approved. So now I need to take you to sections 63 to 65. They start on page 658. That's the heading of the part 7. You'll see that part 7 relates to conservation of the natural environment, and then section 63, starting on page 659 to 65, apply to applications for development permission in conservation areas. And section I don't think I need to take you through the language of them. They require development. They require an environmental impact assessment to be undertaken in relation to any development, and section 63 enables the director to set the scope of an environmental impact assessment, which must still be submitted to him. Oh, I'm sorry, Lord Sales.
Yeah, sorry, just looking at 63, it's talking about commercial or industrial development. Does that cover our case?
Well, if one turns back to section 6, section 4.4 of the National Parks Ordinance, my lord, which is on page 573.
Yes.
That provides that section 63, 64 and 65 apply mutatis mutandis to applications for development permission in a national park. So essentially you replace sections, the words commercial or industrial development with just development, and you replace conservation area with national park area to apply section 63 to 65 mutatis mutandis to developments in the national park.
I see, thank you.
Thank you. So just briefly, section 63 enables the director to set out the scope of an EIA, which must still be submitted to him. Then section 64, he can set, I'm back in the physical planning ordinance, sorry, at page 660. The director sets out particular matters to be addressed in the EIA. And then my submission, I hope this answers your question, Lord Sales, the combination of section 65 and section 6 and 4 of the PPO and section 4.4 of the NPO mean that subject to the provisions of part 7, that's 63 to 65, the applications process for development permission in a national park is the same as that applicable in the case of any other type of proposed development. But the Physical Planning Board shall only make a recommendation on the application to the minister, who must have had sight of the EIA, and the minister then forwards that with his or her comments to the governor, who decides the application. So just a separate layer of consideration is put in to that which is ordinarily applicable in a conservation area, and it applies to any development. And that's because ultimately only the governor can make the grant under section 4.1 of the NPO. But the application must still be made on the statutory form under the regulations in the normal way, and the grant or refusal of development permission will be on the form under the PPO and consequently signed by the director. So there isn't, as Mr. Missick suggests, an error of law in the refusal having been signed by the director rather than the governor. There are therefore 4 stages in my submission to an application for development permission in the national park. First, an application for development permission in the normal way, on the normal form, accompanied by an environmental impact assessment in the form and covering the matters approved by the Director of Physical Planning. Secondly, the application and the EIA are considered by the Physical Planning Board, and the Physical Planning Board makes a recommendation to the minister, which is accompanied by the EIA, because the statutory provisions say the minister must see the EIA. And then the minister's consideration and comments are sent to the governor, and the governor considers the criteria and factors set out in section 4.1 of the NPO. But 2 things are clear from the combination of section 4.1 and 4.4 of the NPO. Section 28.1 of the PPO, which prohibits development without permission, section 31 of the PPO, and section 65 of the PPO, which is that even the governor can only approve development permission on the making of a proper application under the PPO, and even he can only lawfully grant development permission on the recommendation of a minister who has taken advice from the director if 2 statutory conditions are met. And those are the conditions in section 4.1 of the NPO. Firstly, that such development may be considered desirable to facilitate enjoyment by the public of the natural setting of the area and features of historic interest by the public. And secondly, that the governor has treated as the paramount consideration, limiting that development to the minimum consistent with reasonable access to and enjoyment of the area by members of the public. I believe you wanted a short break about around this time, Lord Lloyd-Jones. This would be a convenient moment.
Yes, thank you very much. We'll take 5 minutes at that point. Thank you very much. Ms. Mountfield.
Thank you. I now then turn with that statutory background to the facts, and I'll have to gallop a little, I'm afraid, but I will keep going. So I'm going to start with the position in 1994, before the respondent was granted a lease over some of the Scilly Creek land, excluding Scilly Quay. And you'll recall that the respondent was established with the commercial object of developing Scilly Creek, which is outside the national park, and also potentially in future the tip of Scilly Quay. And before it entered any formal lease with the Crown over any of the land, the respondent applied on the statutory form to subdivide lands within Scilly Creek and Scilly Quay. And that application in respect of parcel 60400/4, which is the Scilly Quay tip, is in the supplementary bundle at page 1. And the environmental impact assessment filed with that application on the 4th of November 1994 is in the original bundle at page 244. Don't need to turn them up just now, I'll just tell you they're there. And you'll recall from the summary of the physical planning ordinance that subdivision into separate lots is a form of limited development provision under section 29C of the PPO. And permission to subdivide is defined simply as granting the right to subdivide land subject to the terms and conditions of the permission to subdivide. And in section 2 of the PPO, to subdivide is defined as meaning to divide a parcel of land into 2 or more parcels. But that's all. So subdivision of the land, while potentially envisaging future development in lots, does not itself amount to permission to construct roads, housing, or anything else. It's the first step of the process. And it's a different beast from outline development permission for a particular type of development, which is provided for in section 29A of the physical planning ordinance. But the fact that the subdivision application was accompanied by reference to those future plans, the land use plan, the master plan, what the developer intended to do with that land, does not mean that the purported to consent to subdivide in 1994 amounted to consent, any consent, even conditional consent, to the uses of the land for which the subdivision was sought. Otherwise, section 29A and section 29C of the PPO would be the same thing. Now, on the 14th of December 1994, the subdivision application was purportedly granted by the Physical Planning Board, and that's on page 298 to 299. It's on form DOP 12. I say purported because the Physical Planning Board, in fact, had no power to grant subdivision of Scilly Quay, because the land is designated in the national park. So only the governor can make the grant of any kind of development permission, even simply to subdivide parcels of land. And there was no evidence, actually either way, before the board, that the Physical Planning Board was acting to implement the governor's decision. But even if, as seems likely at this stage, a presumption of validity saves the 1994 grant of permission to subdivide from being treated as void and of no effect, insofar as it applied to the national park land on Scilly Quay, there are 2 reasons why it could not now be treated as even outline permission to develop Scilly Quay. The first is that no works took place on Scilly Quay, so that permission expired within 3 years in any event. And the second reason is that the purported grant of permission to subdivide plots at Scilly Quay couldn't give rise either to permission, statutory permission, or to a legitimate expectation of any particular form of future development on those plots. Now, after that, the respondent entered into the 1995 lease, which you see at pages 311 and following of the bundle, to develop land in Scilly Quay, which is Scilly Creek, outside the national park. And it is noteworthy, in answer to the question I was asked at the beginning of this hearing, that for each house, it seems to have applied for development permission through the normal statutory procedures. There's one example I found in the bundle, page 442, and that's an application for permission for a house at Scilly Creek, which was refused because of issues about the heights of buildings. But what it shows is that you see the respondent following the PPO processes that it had made an application for subdivision in 1994. There's a reference to an outline development permission, PR 3213, and then a detailed application, PR 6067. But the respondent doesn't suggest that it ever applied for any form of outline development permission under section 29A of the PPO for development in Scilly Quay. Instead, the respondent appears to invite the board to treat the 1994 subdivision decision as if it were a conditional approval or recommendation to the governor for approval for the types of development which were mentioned in the subdivision application, which conditional approval, it suggests, somehow lay dormant until it sprung into life 12 years later in 2006, when the governor signed the settlement agreement. But some kind of conditional permission cannot be the effect of a form DOP 12, which was signed on the 14th of December 1994. At the most, it was an approval of subdivision granted in 1994. And it isn't a permission to make any further use of the land. It shows at most that in 1994, the Physical Planning Board had no objection to subdividing Scilly Quay as a separate parcel of land at the Land Registry. But the respondent submits that while the Physical Planning Board grant of permission to subdivide couldn't bind the governor, or indeed any form to grant subdivision or indeed any form of development, in 2006, by entry into the settlement agreement and 2006 lease, the governor did in substance grant development permission in the park pursuant to section 4.1 of the NPO. And that argument attracted the Court of Appeal in this case. But I submit that once you look at the statutory scheme, this kind of gluing together submission bears absolutely no relation to the statutory procedure, statutory and mandatory procedure for the grant of development permission. It treats the 1994 grant of permission to subdivide as a kind of conditional permission, not only to subdivide, but also subject to the governor's approval to develop for the purposes which the developer had indicated on a land use plan it intended when the application to subdivide was submitted. Then it suggests that notwithstanding the terms of section 37 of the Physical Planning Ordinance, this kind of conditional outline permission could somehow lurk alive but in abeyance for 12 years until the settlement agreement and the 2006 lease, whereby the governor contractually indicated an in-principle approval of the land use plan. And then they suggest that at that point, the settlement agreement should be deemed to be section 4 approval for some kind of previously conditional but outline consent for some kind of residential development on Scilly Quay, which has been in principle approved but held in abeyance for 12 years and then brought into life by the governor's contractual fiat. And while the respondent accepts it still requires detailed development permission to construct houses on Scilly Quay, it submits that its 2009 application for that detailed development permission could not properly have been rejected on the basis that it was, which I showed you, namely that the type of proposed development, private housing, was outside the scope of section 4.1 of the National Parks Ordinance. So that's how we understand the respondent's argument. And we submit that the board should reject the very first building blocks of this highly artificial analysis. Because the 1994 subdivision permission was permission just to subdivide. It gave no permission to develop on Scilly Quay. It was permission, it wasn't conditional permission. There's no such beast in the Physical Planning Ordinance except insofar as a permission can be granted subject to conditions. And yes, Lord Sales.
Sorry, I was just looking at page 298, which is the grant of permission for subdivision. And note 2 says, in terms, this grant of permission is valid for 3 years from date of notification. So would I be right in thinking that even according to the terms of this permission, it's lapsed anyway?
Yes. Well, I think I need to see what the respondent said, because I think they say they did some works subject to this permission, but not on Scilly Quay. They did works, they did them in Scilly Creek.
Yeah, but this, I'm right in thinking we're looking here at, or are we looking
Yes.
at Scilly Key?
I think we might be looking
When
at
it refers to Scilly Creek development, was it in fact then a permission which covered both Scilly Key and Scilly Creek to
Yes.
subdivide?
Well, my lord, you'll see that the application to subdivide relates to 2 parcels of land, 58 and 4 is Scilly Key.
I see.
And we say that no works were carried out on 4. So I think they were previously 1 parcel of land, and Scilly Key and Scilly Creek were divided.
Right.
Yeah.
So just to pursue that, that would suggest that if this is to be read as, if you like, 2 grants of permission in respect of 2 distinct parcels of land, insofar as it's a grant of permission to subdivide in relation to plot 4, it has lapsed. Is that right?
Well, as I understand, the 2 separate plots were then, well, we'll get this in when I respond to Lord Limblom's request for the register. The subdivision was registered at the registered land registry. So that would have been, if, as I say, it was just permission to subdivide, that was it. The subdivision happened. That was all it permitted. So I'm not sure it did lapse.
What does it mean on the opposite, on the next page, by saying the requirements for outline provisions shall be carried out as the development proceeds?
Well, my lady, I'm not aware that there was any other outline permission. So my submission would be, but this is as it seems to me, submission is that if outline permission is sought and obtained, you have to comply with the conditions, any conditions that may be in it. It's not suggesting that this is an outline consent for anything, because it was an application under section 29C, and that's what the form DOP 12 is. DOP 12 is permission to subdivide, not outline planning permission, which is a DOP 10.
Well, at any rate, when you produce the document that Sir Keith Lindblom asked for, perhaps you could clarify what the position is in relation to this permission.
Yes, I will do.
Thank you.
Yes. So what I say is it was permission to subdivide. It wasn't conditional permission to develop. And the 2006 settlement agreement and lease provided for application for development permission. It didn't follow, none, as we submit, no procedures for seeking the grant of either outline or full development permission were made until 2009, and that could not itself make the 1994 application for subdivision into some kind of outline consent or application for consent or anything of that kind.
Could I just come back to 2 points? One is the point that my Lady Arden has raised. A little difficult to piece together quite how these conditions work, but if you go back to the page 298,
yes,
subject to compliance with the following conditions. Condition 1 is see notes 2 and 3 below, which I've taken to be the notes on the same page under the capitalized heading notes. And then condition 2 is the condition I mentioned a little earlier, which says the development agreement shall be submitted to the Department of Planning when signed. And you gave an answer about that. And then condition 3 is see over leaf, which I take to be numbered paragraphs, subconditions 2 and 3, one of which my lady referred to. So there are a number of loose ends, apparently, that this planning history we're going to receive may prove to tie for us. But at the moment, on your answer previously, there's no development agreement at any stage. And you say the requirements for outline permission not.
Yeah. Yes.
So
yes,
what effect would those failings have on the status of the 1994 subdivision commission you submit?
well, my lord, I think what I say about the 1994 permission is the most it provided was permission to subdivide and no more. So, because all parties understood in 1994, bearing in mind that the respondent, Scilly Creek Development Company, had no interest in any of this land at that stage, and everyone understood that no decision had been made, even in principle, to allow residential development on Scilly Quay. And that's clear from the 1995 lease that was entered into in relation to Scilly Creek, not Scilly Quay, because clause 11.3 of that lease, which is page 327, said that as soon as the development of the Scilly Creek area demised in the lease was 60% complete and various other conditions were met, which might include recommendations of a future EIA, then the Crown would, future tense, give favourable consideration to any proposal to further demise Scilly Quay, that's parcel 604004, to the respondent for development, provided that the nature and scope of any such proposed development met the approval of the Department of Environment and Coastal Resources. So it's obvious from the context that the proposal was something in the future in 1995 and was conditional on the approval or otherwise of the department at a future date. And the 1995 lease referred to the permitted user as the establishment and operation of a residential community within Scilly Creek, not on Scilly Quay, which wasn't part of the land demised, in accordance with the appended master plan. Now, that master plan, which is page 11, the electronic bundle, isn't, we submit, a document recognised by the PPO. It just refers to plans which were submitted by the respondent as part of the subdivision application. And we say this because copies of the master plans appear at the end of the 1995 lease and have stamped on them grant of permission to subdivide land by the Physical Planning Board, dated the 14th of December 1994. That's at page 330. So we submit that the reference to planning approval must have been to the subdivision permission only. And we say again, I mentioned this in opening, that the so-called master plan, page 262, which was submitted with the 1994 EIA, which has one lot down as BC Private Beach Club and Pool House, isn't the same as the land use plan, which constituted Schedule 1 to the 2006 lease in 345. Yes, my Lord Stevens.
When you're preparing the agreed statement in relation to the planning history, could that condescend to whether or not the governor was involved with this consent on the 14th of December 1994?
Do my best, my Lord. So, subject to instructions, yes. The respondent's case that by executing the settlement agreement and lease, the governor had exercised his discretion under section 4.1a of the NPO to approve the type of development in the master plan, cannot survive scrutiny of the statutory scheme. Firstly, it depends on the submission that the 1994 decision took the form of a recommendation to the minister rather than the grant of permission to subdivide, but that's not what the decision was, as described on form DOP 12. It expressly stated, the point my Lady Arden made a moment ago, that the requirements for outline permission shall be carried out as the development proceeds, which implies future outline permission was required. And even if the subdivision consent could be treated as some kind of conditional decision which endured for 12 years until being joined up with the governor's consent in the 2006 agreements, it couldn't, by some alchemy, shift from a section 29.2c subdivision consent to a section 29.2a outline consent. And finally, the 2006 decision couldn't have been a grant of section 4 consent. 2006 agreement couldn't have been a grant of section 4 consent because none of the procedures specified in the PPO or the NPO for obtaining such consent were complied with. So the respondent's analysis is artificial and wrong. And while we accept that the respondent had an intention to develop lands in accordance with the plans submitted, the Physical Planning Board and Executive generally can't be taken to have bound their hands to allow those types of development to go ahead. The respondent was a property developer, and their final plans remained at risk until further development permission was granted. And as I've mentioned, and we've also discussed, the respondent has problems of timing if it seeks to claim some kind of extant permission. If the purported grant of permission to subdivide could somehow be read in 1994 as an outline permission to develop for residential purposes, which was already envisaged when the permission to subdivide was sought, that permission, which we say doesn't exist anyway, but if it did, it would only have been valid for 3 years until 1997, and then it would have lapsed, as my Lord Sales was saying. If the reason I couldn't answer that question was because I see it's only as a permission to subdivide, but if it were also some kind of outline residential consent, that aspect would have lapsed by 1997. And even if the 2006 settlement agreement itself constituted some kind of outline development permission, then section 37(1) of the PPO would provides that such permission only lasts for a year if there's no subsequent application for detailed consent. And there was no such application until 2009. The respondent's submission isn't that it had already been granted detailed development permission, but that by executing the settlement agreement and lease, the governor exercised his discretion to approve the type of development that he did. And what is the type of development is pretty unclear. It seems to be a broad assertion that the governor granted outline permission to build private housing of some kind in Scilly Quay, so that he couldn't afterwards say, you can't build a house here. But as I've shown you for some length, the governor, who is the ultimate decision maker, was self-evidently not exercising the power to grant any form of development consent under section 4(1) of the NPO, because there was no such application as required mandatorily by the legislation in 2006. And I've also shown you, even where the governor is the ultimate decision maker, section 4(4) of the NPO provides that the modified application for procedure for an application for development permission in sections 28 to 30 and 63 and 65 of the PPO still apply. And the respondent knew that because that is the procedure it went through when it applied for subdivision consent in 1994 and for development permission in September 2009. And there's a letter, I don't think I take it to you in view of the time, but 379 from the architect, the respondent's architect, which specifically recognised in December 2009 that there was a need to apply for permission under section 63 to 65. Whereas in 2006, there was no application form, no valid and up-to-date EIA as required by section 63 of the PPO, no recommendation from the planning board, no consideration of comments from the minister, and no consideration by the governor of the statutory criteria in section 4(1). So the respondent's reliance on the presumption of regularity is misplaced because that applies where on the face of it, there's a decision on the register, for example, that's been made pursuant to a particular provision or particular scheme, and then certain conditions that should have been fulfilled before that took place haven't taken place. But here we don't have any kind of application and refusal or grant on the register at all. So whatever else the lease was, it wasn't by 2009 a grant of outline permission to build houses as specified in the master plan. And the three reasons for that are because any such application would have been had to be made by through the procedure set out in the legislation, and if been granted, have been made on form DOP 10, as the Supreme Court judge, the Chief Justice Ramsey Hale, observed. Secondly, because even if the 2006 application settlement agreement did amount to some kind of outline permission, it would have lapsed by October 2007 because of section 37 of the PPO. And thirdly, because even if the governor had purported to grant outline planning permission to build housing, that would have, as a matter of law, fallen outside the type of development which the governor could ever lawfully have permitted in a national park by section 4, virtue of section 4(1) of the NPO. So the Respondent's primary argument that it already had some kind of development permission to develop Scilly Quay is untenable in the light of the statutory scheme. So the next argument then is whether there was a breach of legitimate expectation. Perhaps there is no statutory right to develop, but the respondent says they have a legitimate expectation based on the way the governor proceeded that they ought to have been granted such permission. And we submit that neither the settlement agreement nor the lease engendered any legitimate expectation that private residential development be permitted to proceed at Scilly Quay. The principles which were clarified by the Privy Council in the UPS case are not in dispute. The UPS case is starts at page 2025 of the electronic bundle. I'm sure your lordships and your ladyship are very familiar with it. It was a case that arose when the government of Trinidad and Tobago took control of a large insurance company with a substantial deficit on its balance sheet. And to avoid a run on the company, the government made a series of announcements assuring policyholders that all sums due under the policy would be paid. But a later government decided that making provision for full payment would seriously disrupt the state's finances, and that instead it would buy out policyholders at a discount over a period of time. And the board of the Privy Council held that even in that case, if the claimants had had a legitimate expectation in the light of the previous government's assurances, the Court of Appeal had been entitled to conclude that it was justified in refusing to fulfil the expectation given the macro-political and macroeconomic policy considerations. Lord Neuberger summarised the law, paragraphs 37 to 39, 2037. I won't take you to it, in view of the time, but I would also invite you, when you look at this in the longer discussion in the speech of Lord Carnworth, looking at the principles of legitimate expectation, to note that Lord Carnworth emphasised the following. Firstly, that in Coughlin, the case which is now the basis of the modern law of legitimate expectation, a promise could only be relied upon if the promise was designed to promote the authority's statutory functions. That's paragraph 111, page 2054. Secondly, that caution is needed in cases where what is claimed isn't a procedural approach, where it's said someone is entitled to have certain matters taken into account when a decision is made, but a claim for a legitimate expectation of a substantive benefit, which may conflict with the discretion of public authorities to formulate and reformulate policy, taking into account a wide range of matters in the public interest, and adjudication upon which is generally regarded as beyond the bounds of judicial competence. So you need to be careful not to apply the concept of legitimate expectation in such a way as to prohibit the public body from exercising its discretion in the light of all relevant considerations in the public interest. And Lord Carnworth said in paragraphs 112 to 113, 2055, that only exceptionally could such a claim succeed. Looking at what the respondent claims here, it isn't quite clear what expectation they claim to have, whether it's that residential development permission would be granted inside the national park, notwithstanding the policy considerations and statutory scheme to the contrary, or that the government would exercise its discretion in the context of a long-running and contested public consultation on this issue to take Scilly Quay out of the national park so that it could comply with the expectation that was said to be engendered without breaching section 4 of the National Parks Ordinance. But we say that however the claim is put, it can't succeed for at least 4 reasons, applying the established approach in the UPS case. Firstly, there's no clear and unambiguous representation devoid of relevant qualification as to how the governor would act. The terms of the lease and the settlement agreement could not, on true construction, have been read as containing any clear promise to the respondents, devoid of any relevant qualification. We do accept that the language of the settlement agreement at pages 341 and following gave the impression that the governor did not oppose the principle of residential development at Scilly Quay, particularly paragraph 1 of the settlement agreement at page 342. And we do accept that that the lease said that the permitted user was residential development 345, and that supports that understanding. But there was a relevant qualification. Having regard to the terms of clause 6.5 of the lease at page 355, which made it quite clear that development permission was still needed for any development as required by the applicable ordinance or subsidiary legislation. Also, clause 6.25 at 358 is a promise by the developer to comply with the laws of the Turks and Caicos Islands, which, as I've shown, require an application for development permission to be made in the proper form. And clause 8.5, which 362, which makes the Crown's promise subject to the lessee acting in accordance with directions of all relevant authorities. So clear at least that the promise to permit development was subject to the respondent meeting the requirements of various planning and land use ordinances. I won't take you in view of the time to the Dudley Muslim Association case, which starts at page 1511, but that's a very similar principle where a lease was entered into with a view to development, but if the development wasn't done by a certain time, then the lease lapsed, and the claim that there'd been a breach of legitimate expectation when the lease wasn't renewed was struck out. Sorry, when planning permission wasn't granted, was struck out because it was said, paragraphs 29 to 30, that the contract was clearly subject to obtaining planning permission within a reasonable time. And the public law principles don't mean that there's a wider suite of remedies available for breach of contract. The second reason that the legitimate expectation claim must fail is that to the extent there was a promise, to the extent there was a clear and unambiguous promise devoid of qualification to support or permit development, it wasn't one that the governor could lawfully have made. And Lord Neuberger made it quite clear in the UPS case that an unlawful promise cannot be the basis of a legitimate expectation. The language of section 4 of the NPO is quite clear. The land must be open to members of the public for recreational use, and a private house could never be. The governor could only grant development permission for such development as may, objectively, be considered desirable to facilitate the enjoyment by the public of the natural setting. And plainly, a private house cannot rationally be considered to fall within that category. And in any event, the primary consideration had to be to limit such development to the minimum consistent with reasonable access and enjoyment to the area by members of the public. And that language, I emphasize the definite article. It's not like the public sector equality duty that access is something to which due regard must be given, must be taken into account. It's not even like duties in some immigration statutes to have regard to the best interests of a child as a primary consideration. This is the strongest of language. The paramount consideration shall be minimising development to that which is only necessary. So if the respondent were right, and it had some legitimate expectation for residential development, the governor could effectively act to circumvent the environmental safeguards in the PPO and the MPO by contract, and that's contrary to the purposes of the legislation. I rely on what Lord Neuberger said in the UPS case, paragraph 38, that the principle cannot be invoked if or to the extent that it would interfere with the public body's statutory duty. And I also rely on the references in paragraph 65 of our written case to cases like Credit Suisse to the same effect. My third submission on this aspect of the claim is that the duty to consider an application for planning permission or whether to include or remove land from a national park both give rise to broad and open textured discretions which must be exercised having regard to all relevant considerations and in the public interest having regard to the statutory purpose for which the power is granted. And as the learned Chief Justice pointed out at first instance, there is very long-standing authority that the Crown cannot bind itself as to the future exercise of a discretion which must be exercised when the time comes to exercise it in the public interest. And she cited the Amphriti case in 1921. There are other, that a mere expression of intent to act in a particular way in a certain event is not competent for the government to fetter future executive action, which must necessarily be determined by the needs of the community when the question arises. And there are more recent instances, including some of those cited by Lord Carnwath and UPS, and more recent cases like Cudgeon and Page, which are in our written case, paragraph 64, page 474. And then fourthly and finally, even if there were any such statement as could give rise to a legitimate expectation, which we submit there is not, it would be proportionate to depart from the assurance in the wider public interest, having regard to the national interest in preserving the national park, which was a proportionate response to departing from any such expectation, and the strong views expressed in consultation responses, which I'm afraid is the whole of volume 2 of the authorities volume to that effect. The respondent suggests there's no evidence about this, but there is, mentioned by the Court of Appeal at paragraph 67. It's the evidence of Leroy Charles, the Director of Planning, and you can see that at page 211 of the bundle. That's the reference in the Court of Appeal's judgment, and 215 is the evidence itself. And finally, a breach of legitimate expectation at common law doesn't sound in damages. The Court of Appeal held, and we don't dispute, that the respondent may be entitled to some form of private law or perhaps equitable remedy in relation to the promises made in the contract, and that those should be or should have been considered at a split trial, which the Chief Justice had originally ordered, and the Court of Appeal remitted that matter to her. There's no appeal against that remission, and this is a matter for the Supreme Court to assess. But we do say that the provisions of the settlement agreement, which purported to allow for residential development, are void, and so cannot found a claim for damages. There may be a remedy for unjust enrichment, which is pleaded, but we go no further than that. So we submit that the Court of Appeal's judgment was entirely based on its conclusion that from 2006 the Governor had already granted some kinds of development consent under Section 4 of the NPO and couldn't resile from that. And if, as we submit, that was wrong, then the Chief Justice's first instance judgment should stand, save that if the respondent wants to claim it has some right to damages or other compensation, then that claim should be considered by the Supreme Court in the light of the terms of the consent order 62. I'll turn then very briefly, Lady Arden.
I can ask my question at the end or now. It was simply this, to say on the subdivision question, which we're clearly going to have to come back to. I do note that the PPO describes in the supplemental bundle, describes outline planning permission as including subdivision. The board does from time to time meet strata title, and it sometimes plots are subdivided with a recognition that they may be sold. And I just wondered if there was a policy on what subdivision means in these islands.
My lady, I'd have to take instructions on that. I'm afraid I don't have an answer to that immediately.
The reference I looked at page 42 of the supplemental bundle, and there are other references to strata title. It says there an application for outline development permission, including the subdivision of land into strata lots. I think these probably were strata lots.
Yes, I don't know, my lady. I'm then going to turn briefly to the question of whether the Court of Appeal should have considered, and the board should consider, the claim for constitutional damages. And my short answer to that is that the Court of Appeal ought to have refrained from embarking on that constitutional adjudication because the Supreme Court has original jurisdiction on that issue, as the Court of Appeal recognised at paragraph 78 of its judgment, and didn't address the issue. So the Court of Appeal shouldn't have taken it up de novo. But then, as we've said in our written case at paragraph 73, 476, both constitutions allow for application to the Supreme Court for redress. So it's not really strictly a jurisdictional argument, it's a restraint argument that the matter shouldn't have been considered by the Court of Appeal before the Supreme Court had considered it. And the claim the Supreme Court wasn't fully pleaded, wasn't pursued. We had no idea which constitution was being relied upon at the time. And so there was nothing to appeal in that regard. But more significantly, the Court of Appeal didn't consider the impact of the potentially available relief in equity or at common law to its exercise of discretion. It remitted the matter to the Supreme Court, but it made no real sense, and we submit was inappropriate for the Court of Appeal to seek to decide the question of whether constitutional rights had been breached, unless and until the question of any relief at private law in equity had been determined, because Section 18(2) of the 2006 Constitution and Section 21(2) of the 2001 Constitution, pages 717 and 737 respectively, confer that power on the Supreme Court. And I rely in general on this, in view of the time, on paragraphs 108 to 113 of my written case, 486 to 489, especially paragraph 108 C. Then, if I do need to deal with it, the Court of Appeal's error in approach to the constitutional claim, again, I'm going to have to, in view of the time, ask you to take as my submissions on this are written case, and particularly the summary of the Article 1, Protocol 1 case law there. But I draw particular attention to the following three principles. A dispute, this is a different case from Pine Valley, because the Pine Valley Estates case involved an outline planning permission which was there and on a register, and then it turned out that detailed consent could not lawfully be granted. Here we say that if we're right, that there is no statutory right to planning permission at all, then there was no statutory right, which was extinguished by the 2009 decision. So if there's a property right at all, it's a right which arises from the terms of the settlement agreement and the lease. The Kopecky case, in my written argument at paragraph 81, explains that a disputed claim is not a property right per se. And we say that to the extent that there was a property right, that should be resolved by the determination of the Supreme Court in the split damages hearing. And I also draw attention to the Ilchenko and DePaul cases, which I've cited in paragraphs 87 and 88 of my written case, protecting environmental interests and supporting the rule of law and proper procedures in relation to construction decisions are particularly strong public interests, and compliance with those, or giving effect to those interests, can defeat a claim of interference with an enjoyment of the property in the wider public interest, especially in a coastal area. So we say there wasn't a breach of a legitimate expectation, there wasn't a protected possession here, and if there was, it was a contractual right and should be considered by the Supreme Court. So then I respectfully invite the board to allow this appeal, and the relief I seek is in paragraph 113 of the written case. We invite you to set aside the entire Court of Appeal judgment. We invite you to declare that there was no extant planning permission at Scilly Quay. That is, that the 2006 agreements did not and could not have constituted a grant of outline consent under Section 4 of the NPO. Thirdly, that in any event, the promise in the 2006 agreements was void and of no legal effect. So the Court of Appeal's findings on damages were wrong and should be set aside. Liability to damages. The question of relief flowing from the finding that promise of permission to develop was void should be remitted for consideration by the Supreme Court, because there may be some aspects of the contract that did have a value. So what the loss is should be determined by the Supreme Court, and there may be a restitution claim to be considered there. And finally, that any questions about proceeding with constitutional claims, including directions for doing so, should be remitted to the Supreme Court to consider and to be properly pleaded. So I'm sorry that that was rather hasty when it came to the constitutional claim, but subject to any questions, those are my submissions.
Thank you, Ms. Mounfield. It had a lot of ground to cover. Mr. Missy.
Thank you, my lord, my lady. Before the break, can I just consider with your lordship a few of the statutory provisions that you were taking to? And if I could ask your lordship to look first at the definition of development, which you will find in the physical planning ordinance at page 617 in the authorities bundle. That's behind tab 5. And it says, development means the carrying out of any building, engineering, mining, or other operations in or over or under any land, the making of any material change in the use of any building or land, or the subdivision of any land. So there are 3 types of development that's recognized under this provision. There are building operations, there are change in use, and there is subdivision of land. And that is given effect to, at least partially, by Section 29, which your lordships, which the board was already referred to, which sets out the 4 types of development permission, one of which includes subdivision of land. So subdivision of land is a recognized form of development permission. And when land is subdivided, it is subdivided for a particular purpose. Because as your lordship might have seen, or perhaps you didn't see it in the application to subdivide land, the applicant is required to state the purpose for which each of the subdivided lots are to be used. And so when an application for development permission for vacant land is applied for, when an application to subdivide vacant land is applied for, there are 2 types of permission that are consequential on the grant of that permission. One is a change of use, because up until that point, the land was vacant land. That was the use to the vacant land. And then secondly, there's the permission to subdivide the land for the purposes for which the subdivided lots are to be used. The second provision of the PPO that I would ask the board to look at is Section 11. Which requires that the director sign development permissions for land. And at subsection 3, to which you were referred to, that's at page 625 in the authorities bundle. Section 11.3 says, the director shall sign and issue all development permissions, refusals of development permissions, enforcement of notices, and other documents authorized by the board to be issued under the provisions of this ordinance. So Section 11.3 applies only to development permissions granted by the board. Nowhere in the ordinance itself or in any regulation does it specify the form in which a decision made by the governor is to be given. And if I can ask you to look at Section 39 of the Physical Planning Ordinance. This is at page 642 in the same bundle, authority bundle. Section 39.1 says, without prejudice to provisions of this part as to the lapse or modification or revocation of any grant of development permission, shall grant, except insofar as the grant otherwise provides, endure for the benefit of the land concerned and of all persons for the time being entitled to an interest in the land. And that, together with Section 29, as you would have seen, which states that the planning permission is for the benefit of the grantee and its successors, shows that development permission is attached to the land. And you will refer to section 79, which requires the director to maintain a register in which all development applications are to be entered. I would simply make the point here is that the obligation to enter the particulars are imposed on the director. And if there's a failure by the director to enter or to make the appropriate entry, that cannot be held against the applicant or held against the grantee of the development permission, assuming one was issued. Now, can I at the very outset, before I go into the 4 issues raised on the appeal, indicate to the board what is the respondent's position. The respondent does not say that there was the grant of any development permission in respect of Silly Key in 1994. And it is not the respondent's case that the 2006 agreements granted outline development permission. The respondent's case is that the 2006 agreements, and in particular the settlement agreement, construed in its proper context, including the legislative context, was the grant of development permission to subdivide the land on Silly Key. With the legal consequence that in making any subsequent applications for development permission, it was not open to the governor to derogate from the permission previously granted. And the appellant's case is that when the application was made for detailed development permission in 2009, and refused on the basis that it was not of the type of development permissible in the national park, this was a derogation or effectively a revocation of the development permission granted by the settlement agreement in 2006, assuming your lordships are willing to uphold that that was the effect. So,
This is a question from Lord Sales.
yes, no.
When you say that the 2006 settlement agreement was the grant of a development permission, of which sort of development permission do you say it constituted?
Permission to subdivide land.
And that's all?
That's all. That is all. And that has always, at least in the Court of Appeal, that has always been the appellant's case.
Yes, I see. Thank you very much.
I see that it's 1 o'clock. So
It's a convenient point, Mr. Missick. We'll resume at 2 o'clock.
After the short adjournment, would it be possible to give us a statement for our note on what exactly subdivision means and what its implication is?
Yes, my lady.
It would be helpful. Thank you.
Thank you. Ms. Mansfield.
Yes, I've had some slightly frantic instructions about the number of people who are in lockdown of various kinds or self-isolation in TCI, and precisely what we are being asked to provide within 7 days. Because if it's every planning application in Scilly Creek, of which I think there may be a very large number, because of a large number of houses that have been developed, that may be quite difficult to provide within 7 days. I think if it's every application on Scilly Quay, it shouldn't be a problem.
Well, we're only concerned with those in relation to Scilly Creek which have a bearing on Scilly Quay.
Yes, thank you.
Right, we'll adjourn now. We'll resume at 2 o'clock, please. Thank you all very much.